Good afternoon, and welcome to the Washington Medical Commission webinar series as part of Patient Safety Awareness Week. Today, we are going to be discussing how to file a complaint with the WMC. Today, I'm joined by WMC Chief Investigator Adam and Chris, the WMC Complaint Intake Manager. Before I turn the webinar over, I would like to take care of a few housekeeping items. We encourage you to ask questions throughout the presentation. So look for the question chat box on your webinar portal, and we will do our best to address your questions at the end of the presentation. We are recording this webinar, and the on-demand version and the slide deck will be available on our website within the next few days. Please feel free to share these resources with your friends and colleagues. Now, as a quick reminder, we are unable to discuss details or answer questions about open investigations and complaints during this talk. But today we will be talking about who the WMC regulates, the materials and resources you may need to file a complaint, specifically how to do that, and then what happens after your complaint is filed, including the review process and following up on your complaint. Now, with all of that out of the way, I'm going to turn it over to Chris.
Good day. The first thing we're going to look at is who we regulate as the Washington Medical Commission. We regulate two specific professions, and those are physicians or MDs and physician assistants or PA-Cs. Any other complaints that you might have in the process of filing a complaint for healthcare would typically be regulated by the Department of Health or some small exceptions to that. Some information that you would need or that is helpful when filing a complaint is the name of the physician or physician assistant involved in your healthcare. And if you can provide any other details about that individual, like their license number and things like that. The location you received healthcare, the name of the facility, and the address. In the information, a detailed timeline of the events that led you to file a complaint, and an explanation of the issues with any supporting documentation you might have, like diagnoses or medication or other services that were prescribed to you at the time. So how do you file a complaint? With the Washington Medical Commission, we have three solid methods for filing a complaint. If you go to our website, you can file completely from our website portal at wmc.wa.gov. If you go to the section that is specifically about complaints and investigations, you can click on a link and it will take you through a step-by-step process of what information you need to complete your complaint. The next method is email. You can email medical.complaints@wmc.wa.gov. We will communicate with you back and forth through that channel. The final method is through standard mail or a letter. And you can send any documentation that you might have and any type of letters that you have to Complaint Intake, Washington Medical Commission, P.O. Box 47866, Olympia, Washington 98504. So what does the process look like when you file a complaint? Any of the methods that you just saw would be delivered to us and we would receive your complaint. Our WMC staff will prepare your complaint, including any imaging or redacting that might be necessary. Our case management team would get a copy of your complaint and do a review for any potential violations of the laws and rules that regulate physicians and physician assistants and the standards of practice that they practice healthcare by. And once our CMT, our case management team, decides whether to authorize an investigation or close your complaint, we will inform you as the complainant what that decision was. Our case management team, or sometimes referred to as complaint management team, is made up of a panel of 3 to 4 of our commissioners. A minimum of 2 of them are healthcare providers. They're either physicians or physician assistants, and one of the members is typically a public member. And each panel goes systematically through each complaint that was received in a week prior and decides whether or not there is potential for violation, or they'll close it if there isn't an apparent violation of the laws that regulate or a deviation from the standards of practice. And now I'll hand it over to Adam, the chief investigator, who will explain the process of authorizing an investigation.
Thank you, Chris. Really great information. So once a case is authorized for investigation, it's assigned to a reviewing commission member, an investigator, and a staff attorney. The RCM, or the reviewing commission member, also known as the RCM, is assigned based on their specialty. So the commission makes an effort to align the knowledge of the RCM with the allegations in the complaint. For cases that involve sexual misconduct, 2 RCMs are assigned. One of them being a public member, one of them being a clinician, and whenever possible, one of them being male and one of them being female. RCMs that are assigned to cases alleging sexual misconduct have specialized training in investigating and assessing allegations of sexual misconduct, including the impacts that such trauma can have on a survivor. Also noteworthy is the investigator has also gone through all of the same training, and oftentimes more training about sexual misconduct and the impacts of trauma, and just taking that sensitive approach to these types of investigation. More about the RCM, their role is to really guide the investigation. RCMs are available to provide direction to the investigator regarding what evidence will be necessary to make a decision on the case. They often collaborate with investigators throughout the entirety of the case when the cases are highly complex. Jumping way ahead real quick, at the conclusion of the investigation, the RCM is going to review all of the evidence to determine whether they would recommend closing the case or if there is clear and convincing evidence of a violation. It's not uncommon for one case to be several thousand pages of data and take many hours to review. But after the review is completed, the RCM makes a detailed presentation to a panel of commissioners at the medical commission meetings, which occur approximately once every 6 weeks. And we got 2 types of investigators. So we have clinical investigators and we have non-clinical investigators. The clinical healthcare investigators must be currently licensed as an MD, a PA, an ARNP, an RN, or a DO. They typically complete investigations regarding the standard of care. So you think of cases where someone is alleging that they were misdiagnosed, which led to them losing their arm or death. These are the kind of cases that clinical investigators will investigate. Cases that require that specialized knowledge in order to be able to ask the right questions and understand the situation. Clinical investigators have the authority to develop an opinion of what occurred and share that opinion with the reviewing commission member for their consideration. Our non-clinical investigators do not make recommendations or form opinions on the cases that they investigate. They are neutral fact finders, working to gather information enough information and the right information that will allow the reviewing commission member to form an opinion and make a recommendation to the commission. Our non-clinical healthcare investigators typically complete cases regarding sexual misconduct, fraud, diversion, prescribing cases, actions taken in other states, and other non-care centered complaints. Also assigned to the case is a staff attorney, and the staff attorney is available to provide that case-specific education to the RCM and the investigator throughout the investigation. And then when the investigation's over, the staff attorney will help ensure that the RCM's recommendations are defendable, that they could stand up in court, and those kind of things. So those are the players of the investigation. And then we get into the investigation itself. So once the investigation gets assigned, one of the first things the investigator will do is send off a respondent notification letter and a copy of the complaint, which is usually redacted. This letter informs the respondent that the commission's authorizing the investigation, and it introduces the investigator to the respondent as a point of contact and informs the respondent of what they can expect to happen next. Shortly after that, within this time frame, the investigator also reviews and assesses the complaint and develops an investigative plan. As I mentioned, for those more complex cases, investigators work very closely with the reviewing commission member to formulate that plan. A typical investigation is going to involve gathering medical records from multiple facilities, interviewing witnesses, interviewing the complainant, interviewing the respondent. Other cases include gathering billing statements, court records, police records, personnel files, and a whole list of other items. Each case is really unique, and it really will depend on the investigative plan to determine what the investigator needs to get. Our interviews are usually completed over the phone or in person, and at the request of the interviewee, it can also be done in writing. Once the investigator determines it appropriate, they will then send a letter of cooperation to the respondent. The letter of cooperation is a letter which contains questions that the investigator has for the respondent based off of the complaint and what they've uncovered thus far in their investigation. The respondent, according to the WAC, the respondent has 21 calendar days to respond to this letter, and the investigator can give a one-time 30-day extension for good cause. Also under the WAC, the basic time period for completing an investigation is 170 days. Once the investigation is completed, the case file is provided to the RCM and staff attorney for review, and then the complaint moves into the next phase of the process. Now, I think that 170 days, when you hear that, that sounds like a long time, and it's a fairly long time, but when you have investigations where you're getting, 5 different sets of medical records from 5 different facilities, you've got to interview 5 to 10 witnesses, so you have to coordinate schedules and get a hold of people. You're interviewing the respondent and the complainant. If the respondent requests an extension, that adds another 30 days. If you need a subpoena, you're adding another 45 days. So it's a lot of stuff that adds up quickly, not to mention the investigator is also managing a full caseload of other cases. So I would say, I think we're pretty close to 90% of our cases being completed within 170 days as far as the investigation goes. But sometimes cases are just going to go over, and it's really nothing that we've done incorrectly. It's just kind of how it goes. So following up on your complaint, when decisions are made, we send out letters to complainants to keep them informed of their case status, right? This is done at the beginning of investigation when it's determined whether or not to investigate the complaint, and then after an investigation is completed and reviewed by the commissioners at the commission meeting. If your complaint was authorized for investigation, the best person to contact would be the investigator assigned to the case. If the case is no longer being investigated, that investigator will be able to reach out to the legal department with your contact information and get you in touch with the right person. If your case was never authorized for investigation, I think that complaint intake would probably be your best point of contact, or the main WMC line. Nothing further there. Other important information just to kind of keep in mind is the WMC cannot interfere with your medical care or treatment plan, right? So we can't tell a provider that they need to stop doing X, Y, Z. That's not our role. We also don't have the ability to change a diagnosis or change a note in your medical record. So just keep those things in mind as you submit your complaints. And that's really all I've got. Jimmy?
Great. So I hope everyone will join me in a virtual round of applause. Thank you very much for such a wonderful presentation. Feel free to use the question box to ask your questions. And while folks are typing those in, we do have some questions that were submitted earlier. The first being, what types of complaints do you receive? And are errors in surgery included in the complaints that we get?
Well, this is Chris again. I can tell you that we get complaints about every aspect of healthcare, from I waited X amount of time in a lobby that I think was too long, to they amputated the wrong leg on my body. We get every type of healthcare situation that you could possibly imagine. We also get reports from different entities regarding malpractice and malpractice settlements.
Now, what is the difference between the choice of a patient to file a clinical investigation request with us versus a private lawsuit for malpractice?
So the big difference between filing a complaint with us and filing a lawsuit is that a lawsuit would be a civil suit that you would have between yourself and the physician, which could result in a monetary judgment or some type of malpractice judgment. I am not an attorney. I can't give you legal advice. But filing a complaint with us potentially could affect their license. And that's the major distinction, that we can potentially seek disciplinary action against an individual, which could include fine, suspension, or revocation, or educational opportunities for a licensee.
Now, Chris, you kind of mentioned in an earlier answer that the WMC doesn't have jurisdiction over, kind of long wait times or, issues that involve inconvenience. But specifically, what about the failure of a medical practice to respond to requests to process financial aid paperwork, not answering a phone call or calling back for requests for appointments, and other issues relating to delaying treatment?
Well, delaying treatment and having disputes with an office staff are different. So if there's proof that a delay in treatment caused future problems, then that is a complaint that we would have jurisdiction over. If it is a disagreement with office staff or a dispute with office staff, in many instances, we don't have jurisdiction, especially if they are considered billing or insurance disputes. We would not have jurisdiction over that unless something is specifically fraud related.
And we didn't specifically cover this in the talk. It's a little bit of a different issue, but it might be good for our audience to know what types of information is releasable to the public and the media.
I am by no means an expert at public disclosure, but when you file a complaint with our either our complaint form or our online system, we follow what is called the whistleblower authorization process, which if you are a patient, you have that right to exercise that you do not want your information released as a patient. If you are a medical provider or a healthcare practitioner who would be considered a whistleblower, you also have that right to not have that information released to the person you are complaining about or the public. And that is something that you need to review in the complaint. If your complaint is authorized for an investigation and we do not have a specific authorization for a whistleblower, we will seek that information from the complainant themselves to decide whether or not, as a patient or another category of whistleblower, whether you want your information released to either the person you complained about or the general public.
Well, that is all the questions we have. So I would like to thank you again for presenting this valuable information, and thank you to everyone for attending and participating. I hope you enjoy the rest of our Patient Safety Awareness Week, and remember to take care of yourselves. Thank you so much.